And so when I've done these pre-planning things, I always think of things of my responsibilities that areas are going to have. And that's what I always want to contribute into the shedding of light on some of this information. Our purpose here today is to give you just a snippet of information. You have people and their intent, and so I ask you to write down your question. Don't lose it. Don't lose the thought. Write them down. Because at some point you're going to want to ask either an exam or yourself and get an answer to your question. So we are not going to be able to have time to tell and explain everybody's situation. But that's why you meet with us if that's what you want, or you're an attorney, or you're a practice, and ask further questions about the questions that you may have. And so with that, I'm going to turn it over to Isaiah.
Thank you, Greg, and thank you to everyone who's here today. I understand this is being recorded, so I'll try to get the best audio I can. So today I'm going to talk about estate planning in general, and keep in mind that everything I say today, there are usually some caveats. There's a lot of specific things that you can get into when you're talking about estate planning. So you'll leave today with a very general knowledge of estate planning, but there's a lot more out there. There are hundreds of different types of trusts and estate planning tools for each specific person. So don't walk out of here today thinking, oh, I need a trust, or oh, I don't need anything at all. It's good to talk to someone on a one-on-one situation. You'll find in the blue packet that says Schlamer, we ended up with the same exact packets today. The one that says Schlamer Law Firm on it, there's some information in there, again, general information about estate planning, and there's a data sheet. So it's important, if you ever meet with an attorney to talk about planning, fill out as much of that as you can, because it really comes down to each person's unique circumstances. There is no one-size-fits-all estate planning. And a question I get a lot is, why don't I just get online, LegalZoom.com, $75, $100, I'll print out a will, sign it, or even online trusts and things like that. They might work for some people, but until you talk to someone who knows your specific circumstances, you won't know if that type of will or that type of trust is for you. And I'll just start with a horror story, just to show you how bad things can get. I have a client. I do a lot of probate and trust administration, so after someone has passed, working through their estate. And I had a probate client whose son had passed away, and he had printed out a will online. But unfortunately, they didn't know that if you are the beneficiary to a will, you can't also be a witness. So the beneficiary had witnessed the signature on the will, and because of that, the decedent, the son, had actually intended to exclude one of his children who had sort of a black sheep, didn't talk to him, didn't even come to the funeral, that type of thing. But because of that mistake, we ended up having to settle with the grandson for, I think it was around $30,000 that we had to pay out of a fairly modest estate to begin with. So there are things that can go wrong, particularly if you're trying to just pull something off the internet and go down that road alone. So at least do yourself the service of talking to an attorney. You may walk out and say, you know what, I don't need to do anything, or I don't need to go with this particular attorney, but at least having that conversation, because they may ask questions that you hadn't thought of before. They may bring up certain issues. For example, owning property in two different states. If you have a home here, but also, a property up north in the Upper Peninsula, and you just have a will. Now you're doing probate in Wisconsin, and you're doing probate in Michigan. Okay, so there's just different reasons that you might not catch if you're sort of just looking online and trying to find things. So that's my kind of big disclaimer. At least talk to an attorney before you sign anything or put anything in place. So generally, and let me just kind of go over what we're going to be talking about. We'll be talking about what we think of as estate planning being the transfer of assets from a decedent to a beneficiary. That's the big picture that most people think of estate planning. We're also going to be talking about Title 19 a little bit. So what happens if someone goes into a nursing home and trying to protect assets for future generations, or the non-institutionalized spouse, the spouse who's not in the nursing home yet. And we'll also talk a little bit about what happens if you're living but incapacitated. So that now we're talking about power of attorney forms: power of attorney for healthcare, power of attorney for finances. So those are the three sort of broad categories that we'll talk about. So I'll start first with estate planning. What is estate planning? Generally, someone passes away. How do we get their things to someone else? Big picture. And for the most part, that's going to be your spouse, your kids. If you're not married, if you don't have kids, then, loved ones, family members, friends, things like that. There is a default in place. If you die without any sort of planning whatsoever, the state will do it for you. In other words, they have said this person will inherit first, then this person, and down the line. If you pass away without any planning whatsoever, if you're married, it will go to your spouse, unless you have children who are not also the children of your spouse. So it's not automatically the spouse. It depends on your situation. If you're not married, but you have kids, then it will go to your kids. If you don't have kids, it'll go to your parents. If your parents have passed, then siblings. It goes down the family tree. So there is a process in place if you have no planning whatsoever. But that's not very efficient. And it's more difficult for your heirs, your beneficiaries, your children, to work through that process if you haven't given them any guidance. And that's why I think most of you are here today, is how do we make that process easier on our kids, on our spouse, on our loved ones, that type of thing. So there are really three methods that you can use to transfer your estate to your beneficiaries or your heirs. The first method is through probate. Probate is the default. It is the court-supervised distribution of your assets. So if you have no planning whatsoever, or if you have a will, your assets will go through the state-mandated probate process. Your will gets filed at the county register and probate. The court will appoint a personal representative to act on your behalf. You'll file certain papers with the court, an inventory, final accounting. You'll post a notice to creditors. You'll get an EIN number. It's a very standardized process, and it can take generally 6 months to a year is our goal, but it can take even longer. All right, and you sort of have this oversight of the judge or the register and probate, who's kind of watching everything you file, making sure you file it the right way. So a lot of people say, how do I avoid that? Because like I said at the beginning, let's say you have property in 2 different states. Now you have to go through that process in 2 different states. And really there are 2 primary ways of avoiding probate. The first method that you may have heard someone say, well, you need a trust. You need to get a trust. That's how you avoid probate. The way a trust works is it's almost like you're setting up a business entity. It's a separate legal entity. And you transfer ownership of all your property into that trust. So instead of you owning your house, the trust owns the house. Instead of your bank account being in your name, your bank account will be in the trust's name. Now, when I'm talking about a trust, for the most part, I'm talking about what's called a revocable living trust. And there's 100 different types of trusts out there. There are very specialized trusts. There's irrevocable. There's testamentary trusts that are created through a will. There's a bunch of types of trusts out there, but for our purposes today, when I say a trust, a very standard revocable living trust. And what that means is you can do anything you want with that property. You're not losing control. So you don't own your house anymore. The trust does, but it doesn't mean you can't live in your house, doesn't mean you can't sell your house, doesn't mean you can't use your house, because you are the trustee of the trust. It's sort of like being the CEO of a company. The trustee of the trust is the one who has the authority to sign on behalf of the trust. And you are the trustee and you're the beneficiary. So how does a trust avoid probate? It avoids probate because when you pass away, you don't own the property anymore. And the trust doesn't pass away. It continues in operation. It just gets a new trustee, someone that you have named as your successor. So we don't have the problem anymore of, well, who can sign a deed to a house if the owner has passed away, right? Because that's the big question, is how do we transfer ownership from a decedent to a living person if the deceased person can't sign anymore? It's solved by the trust because the new trustee gets to sign. So that's the first method of avoiding probate is through a living trust or revocable trust. It's called a living trust because you put your assets into it while you're alive. Okay, there are trusts that are created upon your death, and that's through a will. It's called a testamentary trust. Most of the time we don't do that. There are times and reasons to do it. Most of the time, if you're starting a trust, the purpose is so you can put everything in it during your lifetime, which means your kids don't have to worry about that, or your spouse doesn't have to worry about, retitling things after you're gone. So the trust is probably the most commonly heard of method of avoiding probate. And I'd say 20 years ago, there were a lot of other reasons to do trusts. Most of them had to do with the taxes at the time. Back then, the estate tax itself kicked in after $500,000, $600,000. Anything above that would be taxed at a fairly high rate. That exemption today is over $12 million per spouse. So if we're talking about tax planning in your state, that's a good problem to have, right? So we end up not doing as many trusts as we used to because we've lost the tax incentive. Now, Congress could always lower that back down, and it will go back down on its own in 2026. It'll go back down. We're thinking around $6 million. It's tied to inflation. But again, that's $6 million per spouse. There's something called portability where you're allowed to use your spouse's exemption as well. So again, for most people, we're not going through too much concern with taxes and how your estate might be taxed. We're more concerned with efficiency. How do we get things to your beneficiaries most efficiently? And that gets me to the third method of transferring assets, which is beneficiary designations. I'll use a life insurance policy as sort of an example of this. When you enter into a contract with a life insurance company, you're agreeing to pay them money every month, and they are agreeing that upon your death, they will give money to someone else. And you name that person. You say, to my son or my spouse, whatever it is. Whoever you name on that policy, they're going to get the money no matter what your will says, no matter what your trust says, because a will or a trust has no authority over that contract. That's a contract between you and the insurance company. Now, there are spousal claims and spousal rights, so we don't have to go down that road. But in general, you name someone through your insurance policy, it avoids probate, it goes directly to whomever you have named. Now, you can add beneficiary designations on almost every type of asset you have. Most people have some combination of a house or condo, real estate, bank account, checking account, maybe some investments or a retirement fund, and then personal property stuff, vehicle, the pots, the pans, the couch, things like that. You can put beneficiary designations on almost every one of those things. You can go to the bank and say, I'd like to name beneficiaries on my checking account, my savings account. You can file what's called a transfer on death deed for your real estate. You can name beneficiaries for your retirement funds, for your investment accounts, things like that. So you can avoid probate by adding beneficiaries to all of your accounts and your real estate, because then there's nothing left to go through probate. It just goes directly to that person, much like a life insurance contract. Your beneficiary takes your death certificate, goes to the bank, says, dad passed away, here's the death certificate. The bank will say, okay, we'll send claims forms to whoever we have on file. And it's that simple. So the benefit to that approach is you don't have to go through the whole estate administrative process. Whether you have a trust or a will, you will go through an administrative process of posting a notice in the paper to creditors, getting an EIN number so you can open up a checking account specifically for the administration. You are going to have to go through those steps. Now, a trust makes it easier because you're not dealing with the court. You're not filing, any documents with the court. You just have the trust, and you're kind of going at your own pace. So you have a lot more freedom and flexibility. Again, if you have assets in multiple states, if you have a trust, you're just doing it all at the same time. You're not going through probate in the different states. So it's not as bad, but you're still going to go through some sort of administrative process. With beneficiary designations, it's very simple. It's here's the death certificate. Okay, here's the claims form and the money. Now, there are downsides to that. And the ones that I see most often are that you're not appointing someone as the representative of your estate. So who pays for the funeral? Who pays for any last medical bills? Who decides when to sell the house? So if you have one heir, one beneficiary, it's quite simple. Everything went to this one person. They're responsible for your funeral home, funeral bill. They're responsible for those types of things because they got everything. If you have 7 kids, now all of a sudden you have, okay, everybody chip in an equal amount. Well, I didn't want to have a big funeral. I just wanted to have, I'm not going to pay for this. That was your idea, not mine. And you start have disagreements. With real estate, if you do a transfer on death deed, it just goes directly to whoever you've named, and they become co-owners of this property. So again, 1 kid, 2 kids, probably not an issue. They'll work together, they'll sell the house, split the money, done. 7 kids, now I say, well, I think we should paint the house before we sell it. No, that's a waste of money. Well, we at least have to pull up the carpet because there was a dog and you can smell the dog. No one's going to want to buy it. No, we're just going to sell it as it, and we go down this road. Plus, you have to have 7 signatures on the listing contract, on the offer to purchase, on the closing documents. So again, it becomes much more cumbersome, even though you intended to make it a lot easier, right? So again, there are 3 different methods, and there's no one size fits all. I can't sit here and tell you, you all need a trust, you all need a will, you all need beneficiary designations, because there's so many factors, so many variables that go into that process. But that's the basic options. Sometimes we end up with someone who does a little bit of each. Sometimes we'll do mostly beneficiary designations, but we still do a will. Why would we do that? Maybe there are minor children who may be inheriting, and you want to make sure that they are grown up before they get a certain thing that you're leaving them. Sometimes you want to appoint one person to divide up your personal property, your belongings, right? Because those aren't covered by a beneficiary designation. You can't go around your house and put Post-it notes on each thing. Some people, you can. Okay, I gotta take that back. You can, but it gets a little cumbersome as well. So again, a lot of the time the question comes down to: do you have conflict in your family? Do your children all get along? Maybe it's a blended family. Maybe you have children and your spouse has children, and maybe they get along, maybe they don't. Okay, those are all the questions that you need to think about when you're deciding what plan really fits you. And maybe appointing one representative from each side of the family to work together. That way, no one can say, well, you're preferring your side, or you're taking, something that my family should have gotten, whatever it is. So There are reasons to have a will, there are reasons to have a trust, there are reasons to try to avoid probate through beneficiary designations. In general, we do like to avoid probate. In general, we like to keep it as efficient as possible. Probate can really get clogged down with, for example, a tax return that would need filed. Well, where does the refund get sent to? Generally, it goes to the estate unless you have a good trust setup. And so now we're waiting 2 or 3 years because the IRS lost your return or your amended return, and we're waiting. So we try to avoid probate for that reason. We try to avoid probate because there are fees associated with probate. The court itself charges $2 per thousand of your estate. All right, so the more that's going through probate, the more you have to pay the courthouse. The more you're probably going to have to pay an attorney as well because the documents are more complicated. If you have an agent, let's say you're naming your daughter as your personal representative, but she lives in Colorado. That means she's an out-of-state agent, which means she'll have to file a bond. It's just another step. So when you add up all of the different, I'll say, inconveniences of probate, most people do decide in some way they would like to avoid it, whether it's through a trust or whether through beneficiary designations, is what we find. That's not to say probate is the end of the world. I do probates all the time, and we get through them. All right, it might just take a little longer, and it may be harder to resolve conflict because anyone can walk into a probate action and say, I object to this accounting that my sibling, I think they skimmed off the top. And even if you didn't, you have to prove it. So now we have a hearing. We're in front of the judge. Your attorney is billing you by the hour to prepare for this hearing. And they're not billing you, they're billing the estate, which ultimately you're going to get less, right? So those are the issues that can really come up with probate. So for the most part, people do try to avoid probate. So that's the main process of estate planning. But then there's a lot of things that also come up, and those two things are Title 19, which I touched on at the beginning, and those other fiduciaries or agents that maybe you're still living, but you're incapacitated. So I'll start with that one. It's important to have your healthcare power of attorney done. A lot of the time, if you go to the hospital, they'll ask you, do you have one? And if you say no, they'll say, well, here, fill this out. All right, so many of you might have one, even if you've not done any other type of estate planning. I would still encourage you to have the attorney that you're working with put together a new one because you may not have been explained all of the parts of a healthcare power of attorney. Healthcare power of attorney basically says if I am incapacitated, this person can make medical decisions for me. Now, a healthcare power of attorney has to be activated by 2 doctors that say you are incapacitated. So it's not like you're signing away your rights to make medical decisions. It's just if you get to the point where 2 doctors say you can't make decisions, then your agent will be able to make those decisions on your behalf. Surprisingly, it's not enough just to be married to someone. Your spouse is not automatically your agent. So if you are in an accident and they have to do some sort of surgery and they have to have someone authorize it, your spouse is not automatically permitted to make that decision for you, okay? Same with your kids. Let's say they turn 18 and they're in an accident or they're, at college or something and you get a phone call. The hospital won't talk to you because they're an adult. They're 18, right? You are not their agent yet. So, whether you have a child turning 18, whether you are married or not, you should all have a healthcare power of attorney. The alternative is whoever is trying to make this decision for you has to go to court and file for a guardianship, all right? And now we're back in court, just like probate, right? And now we have to have a hearing. Now we have to get in front of a judge. Now we have to have a physician's assessment done. We have to have all these things in place. And that's the last thing you want to be doing when there's a medical decision that needs to be made, okay? Now you can do temporary emergency guardianships, things like that. Makes it a little bit faster, but for the most part, you want to avoid that, okay? So that's healthcare power of attorney. Then we have what's called a durable financial power of attorney, and it's for, like it says, finances, okay? So Let's say you're in a car accident and you're incapacitated and it's April 10th and tax day is right around the corner and you haven't submitted your tax return yet. Your agent can sign your return for you. Your agent can pay the mortgage payment. They can write a check for you. They can do things on your behalf that need done if you're incapacitated, okay? Now, something that does come up from time to time is someone will be the power of attorney for finances. The person will die, and the agent will continue to try to act on behalf of the person who has passed away. Keep in mind that a power of attorney ends as soon as the person passes away. So you might think, you know what, I don't really need a trust, I don't need a will, I'll just pay the bills, you know, because I'm the power of attorney. Or, you know, you go to the bank and say, oh yeah, I'm a power of attorney on this bank account. I'll just keep on making payments after they're dead. You know, I'll pay the funeral bill, I'll pay the fine, you know, the hospital bills. You can't do that. The minute someone passes, your power of attorney ends. Okay, so that's why some more advanced planning is usually necessary to make that process a little easier. But those are the other two important documents that I think everyone should have, in addition to, you know, either their will or their trust, is your agency forms, your power of attorney for healthcare, your power of attorney for finances. So all together, that is generally what we do when someone comes in. We bundle everything together so that everything is complete. It's signed on the same date, so there's no question about, you know, rooting through old documents, new documents. You like to have a plan that's complete and in one place. So if something happens to you, your agent can go and get that you know, stack of documents, and it will be in there. Okay. Finally, we'll touch on Title 19 planning. And this is a tricky area of law because normally when someone brings it up, it's either too early or it's too late. There's really a sort of sweet spot, and as I explain, it'll become more apparent what that is. Title 19 generally is long-term care assistance from the state. All right, so if you have to go into a nursing home or some sort of long-term care facility and you run out of money, the state will start providing assistance and paying that bill. But the kicker there is once you run out of money, right? So you have to spend down your own money first. When you apply for Title 19 assistance, they're going to ask you two things. First thing they're going to ask you is, how much money do you have? Right? And you say, well, I got $100,000 in the bank account. The state will say, well, then you pay for it, right? You still have this money. The second thing they'll ask you, let's say you do get down to the $2,000 threshold, and by the way, it's $2,000, right? So not much. You do have to spend down essentially everything. They'll say, okay, you're down to $2,000. In the last 5 years, have you given anything away? All right, that's called the 5-year look back. And if you hear people talk about a 5-year look back or a look back period, that's what they're talking about. They'll ask you, have you given away anything of value in the last 5 years? Now, they don't mean, you know, the $25 that you give to your grandkids at Christmas. The things that are traditionally done that you've just continued gifting, that's fine. But what they were running into is it looked like they were going to have to go into long-term care. So then they sell their house to their kids for $1. They transfer all their assets to their kids, and they say, oh, I don't have anything, you need to pay for me now. All right, so it was shifting the burden. It was giving all the benefit to the kids, and then the state was going to have to pay for their care. So that's why they have this 5-year look back period where they say, have you divested, that's the term they use, have you divested any assets in the last 5 years that should have gone to paying for your care? If the answer is yes to that, they say, well, how much did you give away? And then you are disqualified from receiving services for, it's a formula they use based on the average cost of care for 1 day. So you're disqualified for, let's just say, you're disqualified for 75 days because you gave away this much money, okay? I say, well, what am I supposed to do until then? Well, hopefully whoever you gave it to is kind enough to, you know, take you in for that time or give it back or, you know, pay for your care. But that's the risk, okay? And that's why a lot of the time when someone comes and they talk to me, they say, I'd like to, you know, protect some of this. it might be too late. Because if you think in the next 5 years, you may have to go into long-term care and you only have a couple $1,000s to pay for self-care, then that's a very high risk to you. My job is to help you avoid risk. I'm very risk averse. Some attorneys may be a little more, yep, go ahead, give it away. I'm very risk averse because I've seen what can happen if you take that risk and it goes badly. Now, sometimes 5 years later, the kids will come back to me and say, we should have transferred the house. Mom was fine for 5 years. Well, it's like insurance, right? Car insurance. You pay for it each month. You hope you never have to use it. So there is a risk involved if you are divesting your assets. That doesn't mean that there's never a time or a method of transferring some assets that give you some level of protection still, but also make sure that the kids do get something particularly sentimental. What I have found most often is people aren't so concerned about just getting a dollar amount to their kids. It's more, this hunting cabin that was my grandpa's, and the kids grew up going up to this cabin and they love it there, and I just don't want that to fall out of the family. I don't want to lose that. That type of thing. That's more where we will take some educated risks and say, okay, we'll transfer that out because it's not most of what you have, and you have some other assets available to you, and you're in pretty good health. So, the next 5 years, we don't anticipate you would need it. Some people have long-term care insurance, and then that kind of flips the script. Okay, now we can do some Title 19 planning because you're covered for 3 years, for 5 years. So now we're only talking about a couple thousand, that you have to keep aside. Nursing home care is expensive. All right. So when someone says, I've got plenty to cover myself for 5 years, you probably do that math again. All right. Because if you think about average cost of a nursing home, we could be talking about $10,000 a month. It's $12,000 a year, five years of that, $300,000, give or take. And then what if you and your spouse are both, in a nursing home? Now we're talking about $600,000, right? For that full 5-year period. All right. So most people who have more than that say, well, I've got enough to cover it and my kids will get something anyway. So we end up in this weird sort of catch-22 where Title 19 planning ends up not being important for a lot of people, even though it's something we talk about a lot. The other big issue with Title 19 planning is when you do protect that asset, when you say, okay, I've got long-term care insurance, so I'm set, I can last for a while, and I've got my own savings. I'd like to make sure my kids get something. You have to truly give up whatever asset it is that you're transferring. So if you're giving away, the cottage up north, or if you're giving each of your kids $100,000, you cannot control that asset anymore. Right? It is a true divestment. Now, yes, you can put it in an irrevocable trust. You can receive some benefit from that trust. You can receive income, but you cannot have control over it. And when the state is conducting an audit, when they're looking into it, they don't look at just the name on the trust. They don't look at, irrevocable Title 19 trust. Well, okay, it must be good then. No, they look at what actually happens. So if you set up a trust that says you don't have control over it anymore, but your kid's the trustee and he does everything you tell him to do, right? You kind of enter into this side agreement. Okay, son, I'm going to name you as trustee. You're going to get this money, but until then, just give it back to me whenever I ask for it. They will ask those questions. They will look at who actually controls the assets, and they could make a determination that no, this is actually an available asset. So that is a risk as well. And this is the last point I'll talk about for Title 19. There are exceptions to what is a countable asset and exceptions for a spouse. So when someone goes to apply for Title 19 and they have a spouse who doesn't require that long-term care yet, the state does not want to put the spouse out on the street, right? Because now the state's caring for 2 people. So there are certain exemptions when you're filling out your assets, And one of those exemptions is your residence, if your spouse is living in your residence. All right. One of those exemptions is an automobile, a vehicle for your spouse. And then a certain sum of money that changes every year based on a formula. It's around $130,000 or 50% of what you have based on a certain current dollar value. So your spouse can continue to live in your house, can continue to own your car, can have some cash. So it's not, they won't become destitute for you to qualify, but they may have to spend down some amount of money. So there are some things we do if it looks like one spouse is going to go into a nursing home and we're trying to, protect the other spouse. We'll put a new roof on the house. We'll put a new boiler in the house. We'll add value to the house, because those aren't divestments and it's an exempt resource. Go out and buy a brand new car, right? Because it's an exempt resource. So there are tools, there are certain strategies you can still use, even if you didn't get it out of your name that 5 years prior. So again, there are things that you can do. One other thing that we talk about, and Greg may touch on this, is a prepaid funeral. A prepaid funeral is exempt from the countable assets that you have to list as available when they're asking you that question, how much money do you have? So the state wants people to be efficient. They want to make it as easy as on future generations. They want you to be able to have a funeral and for those services to be taken care of. So that's why they exempt certain things like a prepaid funeral plan from Title 19. So there are strategies to avoid it. To be completely honest, most people end up not wanting to do Title 19 planning, either because it's too late, because they don't have enough assets to cover themselves, or because they don't want to give up so much control over the assets they do have. A lot of people just say, well, I'm just going to title the house in my kid's name. All right. Well, what if your kids get sued? What if your kids get divorced? What if your kids, there's all kinds of things. And now all of a sudden your house is at risk because your kids did something, right? Got in an accident and they're being sued. Well, I noticed that house is in your name, right? You're going to put a lien on that house. So there are things that a lot of people are ideas that float around, and you hear it when it works out. It's like, oh yeah, my mom just gifted the house to me 10 years ago and I didn't have to go through any of that process. Okay, but you took a substantial risk and it paid off for you, and that's great, but it was a risky thing to do. So just be cautious when you hear people say, oh yeah, I did fill in the blank and it worked out great, because for every instance of that, there's an instance of it didn't work out great and I lost it, and fill in the blank. So that's the big picture of estate planning in general. Power of attorney forms, things during your lifetime you haven't passed but you're incapacitated, and then some of the specialized planning, Title 19, things like that, that we would talk about in an estate planning meeting. Now again, everyone's situation is different. So everything I've talked about, there's probably an exception to it. How many kids do you have? How old are they? Do you want to put any restrictions on any inheritance that they have? I would like this kid to be able to live in my house for 5 years after I'm gone and then sell the house. We can do that, okay? But that's why it's important to have these conversations with an attorney or someone who knows the different tools and methods available. So with that, I'll open it up to any questions, anything that anyone would like to know about estate planning or the law in general. Yes. Okay, so that's probably not right, because the current tax law for an estate is $12 million before anyone pays $1 in tax. Now, sometimes you will inherit a taxable annuity or an IRA, something that hasn't been taxed yet, a retirement plan, that will be taxed. So, I mean, there's sort of two misnomers floating around. One is that, estates, you're going to get taxed, your kids are going to get taxed on all this stuff. That's not true. Okay, that's generally, they will not pay a tax. Even if they sell your house, and you would think capital gains would come into play, there's something called a step up in basis. When a person dies, the assets that they own, the cost basis for determining capital gains tax goes to date of death value. So in other words, even if you bought your house for $10,000 in 1970, and your kids sell it for $500,000 the day after you die, they're not going to pay $1 of tax on that, all right, because the basis was stepped up. Okay, so, and that actually happens at the death of each spouse. So if first spouse dies, the basis gets stepped up, as long as they owned it properly and it wasn't in some sort of irrevocable trust. Again, these are the sort of small details, like devil's in the details. If you put it in irrevocable trust, it won't get that step up in basis. So another downside to Title 19 planning. Or if you gift it, if you give them your house for $1, that their basis is whatever you paid for it, or even worse, $1. Okay, so no, you will not incur this tax. You will incur tax if you inherit an IRA, just because that money hasn't been taxed yet in general. One common tool, if someone is looking to make some sort of charitable bequest, I'd like to leave my church some money when I'm gone, use your IRA, all right? Because that money will get taxed if you give it to an individual, but a nonprofit doesn't pay income tax. So if you name your church as the beneficiary, or even partial beneficiary for an IRA, they're not going to pay that money. So instead of saying in your will or your trust, $10,000 to my church, and then your kids get your IRA, but they have to pay tax on it, use your IRA, use your qualified money. So taxes do come into play a little bit when we're talking about estate planning, but for the most part, it's not a big concern, at least in terms of the death tax, right? Yes? Mm-hmm. Mm-hmm. Right. Right. Yep. Good question. The question for, I think they're recording. Question is, should I have a secondary agent for, the durable power of attorney, healthcare power of attorney, the trust, your personal representative, successor trustee? The answer is yes. You will generally nominate a primary person. You can nominate more than one person at a time. So for a durable power of attorney for finances, I could name my spouse and my mother, and either of them can act on my behalf. You can name 5 people if you want, but I generally wouldn't recommend it, because then, who's doing what? Too many cooks in the kitchen. Okay. Most planning that we do, we recommend having at least 3 people, in the lineup, so to speak. You've got your primary, and that's usually, either a spouse or one of your kids. And then you have a backup. And one thing that we do run into is, what if you don't have someone, or what happens if, unfortunately, you don't have someone you can trust? There are trust companies out there who you can name to be your fiduciary, to be your personal representative when you pass, or your successor trustee. There are services who you can name as your healthcare power of attorney. Okay, I know Easter Seals in Milwaukee, they'll act as your agent. Now, they charge a fee, but it's better than the alternative. So yes, to answer the question, you'll usually have a primary and then 1, maybe even 2 secondary agents. You can name them so that they're acting at the same time. My strong preference is 1 at a time. It just makes things too complicated when you've got 1 kid in California and 1 kid in Arkansas. They both have to sign every check. They both have to, this type of thing. It really does get complicated. You can make them independent agents, which means they don't both have to sign everything. But then we've got, who's really the contact person in an estate, who really is, they might clash. What happens if they disagree on something? You run into issues there. But yes, you will want more than one. And there are trust companies, banks. A lot of banks have a trust division, and they're willing to act as your representative as well. The nice thing about naming a bank or a fiduciary company as maybe third or fourth is, first of all, they'll never go away. Even if they get bought, generally that trust division just gets rolled into another trust division. For example, we had M&I Bank in West Bend. M&I became eventually BMO Harris. So if we have a trust that names M&I Bank, it goes to BMO Harris. All right. Now, they may not want to do it, but at least we have someone named. You don't have to tell them that you're naming them. You don't have to pay them just for naming them. They only get paid if they actually act as your trustee or your agent. So it's a good backup to have. Yes. The IRA will get taxed at the rate your beneficiary is taxed at. So assume I inherit an IRA from my mom. Now, as an individual, I have 10 years to pull that out. Okay, that we have, it's called a stretch provision, where a trust has 5 years, an individual has 10 years, a spouse has lifetime. Okay, so the spouses are treated better in terms of the IRA. But if I inherit an IRA from my mother, I have 10 years to pull it out. I can do it all in year one and pay the tax then, and that tax will be, what bracket am I in? It would just be like if it was my IRA. So it's dependent on what tax bracket you're in. All right, so let's say you have 5 kids, you name each of them as beneficiary of your IRA. Child A may be in the 20% tax bracket, child B may be in 26% tax bracket. So that all depends on what tax bracket the beneficiary is in. It's not a straight line rule. Yeah, yeah, they would all have 10 years to withdraw it in its entirety. Yep. Yes. Yes, it does have to either recorded in their files, or you have to have an original. Some places will take a copy of it, but you do have to have it. One thing we advise people to do is, after you sign your healthcare power of attorney, take it to your physician, your hospital, wherever. Next time you go for a checkup, they will scan it in and give it back to you. That way, if your kids can't find it, or someone can't find it, at least it's on file with the hospital. So. You can call them, you can, yeah. And if it's at one Aurora, it will be at all Auroras. But yeah, it says that, I don't think they talk to each other, but they will at least talk within their own system. Yeah. Hmm. Yeah. Yeah, so it depends on what sort of estate planning was done. If it was the transfer on death deed, which just transfers the house, was the person still alive that they had 2 power of attorney agents trying to sell their house? Or was the person deceased and the heirs were going to sell the house? Okay. Yeah, so if there's a will and it's going through probate, whoever's named the person representative, they have the final say. If you have 2 people who are your person representatives and they disagree, now we're in court. And one of them would have to file and believe you me, that is the last thing a judge wants to be deciding, 2 bickering siblings trying to work out whether to paint the house or not. judge doesn't want to be there, and they'll get quite upset. Generally, that's why I say you name one person at a time. If it's the power of attorney and the person's still living, and there's two of them arguing, basically what it comes down to is one of them would have to file for a guardianship. A guardianship can trump a durable power of attorney, and at that point you've got a judge, and both siblings would be arguing why they should be the one in charge. They're more responsible, whatever it is. A judge would make a determination, and then you've got one person who can make that decision. But ultimately, the answer to a lot of what happens if there's a conflict is, well, you got to go to court. Yes. Yeah. So we generally say, when you have an estate plan, tell your agents, your future agents, personal representatives, where they are and how to get to them, but don't give them copies of the documents. The reason is you could change your mind. You could change your mind as to who you want to name as your power of attorney. You could change your mind as to who you want to give your estate to. So, for example, I have one person who they said, this one son, they haven't talked to me for 20 years. I want them out. So we did an estate plan, and okay, here's your estate plan, and that son is out. 3 years later, calls me up. Hey, we've reconciled. It's wonderful. I want him back in the estate plan. Okay, we can do that. We'll just do new documents. Here's your estate plan. But if they had taken that original one and given it to their personal representative, now there's this question, was there some sort of undue influence? Are these new ones legitimate? Because I have this old one that cut them out. And so generally I say, you hold on to them. You want to maintain control over them, but you will keep them in an accessible place. Bank boxes, safe deposit boxes are not good ideas, because banks are closed on certain days. They're closed after 5. If there's an emergency, you can't get to them. And they may not give access to your agent because your agent can't prove that they're your agent. They say, well, the proof is in the safe deposit box. Well, sorry, we can't let you in the safe deposit box because you can't prove that you're the agent. So generally, somewhere at home where you would keep your legal documents. There are some states, Wisconsin is not one of them, Arizona is, where you can take a healthcare power of attorney and file it with I don't think it's the Secretary of State, but there's a online database where you can file your healthcare power of attorney. So anyone can look it up. We don't have that here in Wisconsin. And again, I generally recommend you keep control of your documents, because you may change them. Don't hand out all your power of attorney forms to your agents, because you may want to change that, and then you've got to go and get them all back. Say, hey, I made some changes, give those back to me. Because a bank doesn't know if you've made a change. Your financial advisor doesn't know necessarily if you've made a change. So that's where that comes in play. Yes. Mm-hmm. Right. Right. My firm does. I've seen firms where they say, lifetime changes, they generally charge a lot more up front, right? So it kind of depends on how many changes you think you might be making. It really comes down to what change are you making, is how expensive it would be. It's not going to cost the same thing as, the original documents are going to cost more. Making one small change is not going to cost as much. If you're changing, let's say, your agents, and that changes multiple documents, it's going to cost more because we're redoing more documents. If it's, I would just want to add one thing. I want $5,000 to go to my nephew. That's one little change. It's much easier to do that change. But to answer the question, for the most part, yes, you do get charged, each time you make a change. On rare occasions, I've seen attorneys who do like sort of the lifetime thing. A question? Yes. So with a living trust, the idea is you're creating an entity that owns the property for you, so that when you pass away, uh, you still have someone, the new trustee, who can sign to sell the property or to sign the check or whatever it is. So there is some upfront homework when you do a trust plan where you have to go to your bank, you have to file a deed. Attorneys can help you with some of that. When we do a trust, we'll generally do a deed for you as well for your house. But there are certain things you need to make sure do get into your trust. Now we do some backup documents. We do what's called a pour over will. If you're married, we do a marital property agreement. There's certain things we can still do to try to get stuff into your trust and avoid probate, but for the most part, you try to get it done. Yes. That's correct. If you name your kids as beneficiaries, it goes right to them, just like an insurance policy. Yep. Yep. Yes. Yeah, so if one of your beneficiaries passes away before you, we generally put language in there it's either per stirpes, which is Latin, or by representation, which just means that if they had kids, their share will go to their kids, kind of goes down the family line. If they didn't have kids, then it would go to the remaining beneficiaries. There's always a default, there's always a backup, but you can make certain provisions for that as well. You can actually. So when you're listing your beneficiaries on your bank, you can say to my son, Elijah, by representation, which means if he were to predecease. Some banks also have forms where you have your primary beneficiary and then you have your contingent beneficiary. So there's different ways to do it. Yeah. I think we're basically on time. One last question? Not to enforce it during your lifetime. So some people do it on their own. And frankly, some people get about halfway through and then they come to my office and say, hey, we hit a roadblock. Yeah. Right. It is not legally required. Yeah, that's a good distinction to make. For a will or a trust, it's not legally required. Some people do take it on themselves and some people do it. But it's generally advisable. Yeah.
So. When my father-in-law died first, I said, I'm not going to hire an attorney for this. I couldn't read. So I got the legal papers from the probate court, opened the stuff up, like, what's this stuff? It's written in legalese. So once you know what that language is, so I end up, when I went to my attorney, and say, here, please take care of it. You can do this, but just so you know, it's written in legalese.
Yeah. Yeah.
So let's take a 10-minute break. Thank you. Why I wanted to have Joe here. There's so much to ask and know in the state plan. And he's just touched the top of it. I mean, one of the advantages of going to the cruise office is they have a lot of history, a lot of experience, and they can tell you, well, what about this? What about this? What about this? And make you think about, what do I want to do? It's not as simple sometimes as you think. So that's why it's important to speak to somebody with that knowledge. So let's take a break. There's a little snippet over there. You can ask if you have, and come back in 10 minutes to finish up.
So let's continue with our program as you finish your little snacks. That's okay. I want to just kind of touch on something which should be fresh in our minds as Isaiah was talking about. He's talking about all these documents. one of the things you should have is just a binder. And this just happens to be from my attorney's office. That when we did our trusts and our wills, he put it in here. But I also put in here is a list of who my banks are, who my accounting is, passwords on my account, where my savings accounts, my broker account, all that information that if I would drop dead tomorrow, my only daughter could walk into our house and she knows about this, pick it up, and would know what to do and where to find stuff. I used to be a deputy coroner when I lived in Colorado back in the 70s. And one of the things I would have to do is when someone passed away, we had to break into their house. I always went looking for an address book to find out who the next of kin was. There were a couple times when there was no next of kin. And then we're sitting there thinking, okay, what do we do? What do we do with this person that just died? We can't find any next of kin. We've talked to their neighbors. They don't know who they are. What do we do? So that information that you've heard and you're going to hear today, I highly recommend go get a binder. If you have a will, put it in here. If you have a trust, put it in here. And make that list of, this is where my savings accounts are, this is my broker house, this is my accountant, this is where my taxes are. And then if you have children or a significant person that would take care of your death, they know where this is at. Now, I'll tell you, first of all, if you've never done this before and you tell this to your kids, the first question they're going to ask you is, what's wrong? What's wrong? Are you dying? No. I just want you to know this stuff, and I want you to know where it's at. It will become valuable for you someday. The other thing, like Isaiah was saying, you don't give away that document that says, this is my will and this is who I want to take care of things. It's in the binder, and you can change it, you can add to it. It's a codicil that attorneys can take care of it for you. So keep something like this handy. So when it comes to talking about funerals, you got to ask yourself, are there any free funerals? Is there some program that pays for my funeral? Unless you die active duty military, unless you're a policeman and get killed in the line of service, unless you work on a job and they have insurance for you, your relatives or your friends are going to have to pay for your funeral. There are no free funerals. There's a program in Wisconsin called WIFCAP. It's a program that has replaced a program that used to be when someone died and they had no money and the county would pay for them. You've always heard of county funerals way back? Well, WIFCAP will do this. WIFCAP will contribute only $1,500 to the cost of a funeral if it is $4,500 or less. I will tell you right now, funeral costs more than $4,500. So there's a couple of criteria how you even get on this program. You have to be on Title 19 or Medicaid. Title 19, it got that name that when they wrote the law, it was the number of the law that was written back in the 60s, late 60s. And so it just became Title 19, but it's really Medicaid. And for those people that qualify for Medicaid, not everybody qualifies for this program, even though you're on Medicaid, so don't count on it. As Isaiah was talking about Title 19, I think in terms of, that's something that I do not want to plan for, like, okay, I'm going to just let the government take care of me when I get old. No, you don't. Because for one thing, if you go into a nursing home that accepts Title 19, It may be not of your choice. It may be in another city or across town, but it may be not of your choice. And not all nursing homes accept Title 19. You do not get all the premium care that you would get as if you were private pay. And that's important to know, okay? So who pays for a funeral? Ultimately, you do. And people will say, well, Social Security will pay for a funeral. Social Security will pay what they call a lump sum death benefit. It's $255, and it only goes to a surviving spouse. Hear that. It only goes to a surviving spouse. If you have paid into the program, I think they had like 10 quarters at one time, and you have a surviving spouse, they will receive $255. I believe that I will live long enough where the government's going to say no more $255. It used to be that everyone who paid into the program, regardless who paid the funeral, got $255. When President Reagan came into office, he wanted to cut back on expenses on the government, and that was one of the things that he did. And as you hear a lot of stories and stuff in the news about Social Security going bankrupt, there's not going to be enough money in 2035, I believe this is one of the cuts that they're going to make, along with others, but don't expect that to be there in the future. So what do? People will save. People will have life insurance to pay for the funeral. Some people will come in and prepay for their funeral. Not everybody should do that or needs to do that. Some people have enough assets that will be there to pay for the funeral. The only people that really should consider prepaying for their funeral, and there's usually three scenarios, three families that come in. One family comes in and says, you know what, I want to pay for my funeral because I travel around on my motorcycle, I have one daughter, and if I die, I want to make sure that it's all taken care of, that she doesn't have to bother with it. That's one example of who prepays for a funeral. Another family comes in and says, you know what, I just want this taken care of. I don't want my kids to bother with this. I want it taken care of. Another family comes in and says, I want it my way. Not the way my kids are going to do it. I want it my way. And they will make plans for their funeral and they'll prepay it. And then there's the other family that comes in and says, you know what? Dad's going into a nursing home and we were told by the social workers that we should prepay for his funeral because we need to spend down, get rid of his money in a legal way that Title 19 will accept it. And one of the ways is to prepay for a funeral. Now, how much can you put in there? Title 19 does not have a specific dollar amount. They say something that is like a reasonable funeral. Well, what's a reasonable funeral? In our area, expect that funeral is going to cost somewhere between $10,000 and $25,000. It depends upon the funeral merchandise that you buy. Everybody's different. I mean, on Sunday, go out to the parking lot and we have probably 100 different models of cars. Why? They all get you down the road, right? Well, it's the same thing with funerals. People want different stuff. So that's why they may cost as much as they do. If we were living in Boston, or we were living in San Francisco, or New York, you could see funerals costing anywhere from $25,000 to $50,000 to $100,000, because that's how people live. I remember visiting a funeral home, a fellow that I knew in Arlington, Texas, and I was in the manager's office, and he got a call that so-and-so had passed away, and he finished the call, and he told me, this lady that died wants this casket that costs $100,000. And I said, what? He said, it is made this way, da, 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 it's lined with silver, da, 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 da. And it's 100, this was back in 1997. And I'm thinking to myself, who would buy a $100,000 casket? And he told me how her family owns oil, a lot of oil, and she is more than a billionaire. $100,000 to them was pocket change. I think, especially around here, people pay for a funeral the way they live their life. If they drove a Chevy, that's what they're probably going to buy for a casket. I don't see anybody ever overspending for a funeral in our area. I just don't. So people are going on Title 19. The nursing home or the social worker said, go in and make your pre-arrangements, and a family will take part of dad's money and pays for a funeral in Wisconsin, because every state's different. When someone comes in and wants to prepay for a funeral, that money must be held by an independent party. I cannot take that money, put it in my checkbook and say, don't worry about it, Mabel, I'll take care of you someday. Cannot do that. It's illegal. So what we do is we use an insurance company that holds money just for funerals. The family gets a policy in their name and in their social security, which means you own it. We don't own it. The only time the funeral home has access to that money is when that person dies. And they sign a release to the insurance company and they'll send us the funds. That Title 19 will allow it to be used. And there's a document that goes along with that that says that this is excluded from Title 19, and it's an irrevocable trust funeral funds. That's what they're looking for. So either you have life insurance, you have money in the bank, or you prepay for your funeral. That's who pays for a funeral. People will ask me, well, what does a funeral cost? Well, it varies. I'm going to give you some numbers in our area, because if you go to Milwaukee, it's going to be different. If you go to Chicago, it's going to be very much different. But to be realistic, a funeral in our area is going to cost anywhere between $10,000 and $15,000. If you go to Milwaukee and you have a grave open at a cemetery during the week, it's going to cost $1,700 to $1,800. On Saturday, you got to do it before noon. They're going to add another $200 onto that. Don't even ask them to work after 12 o'clock on Saturday or on Sunday or a holiday. Don't even ask them that. They won't do that. Out here it takes place, but not in Milwaukee or larger cities. In 1984, the federal government began to regulate the funeral industry. And what they said was they made funerals make a price list of your services. It's almost like funeral a la carte. Funeral homes were not able to add to that or subtract from that list. Only the things that the federal government, FTC, said you had to have on that list. It had to have special language, disclaimers from the federal government. Every funeral home in the United States has to have that. And they have to present that to you. If they don't, they are in violation and subject to some pretty heavy fines. And every now and then you'll read in our national funeral directing papers, some funeral home was audited by the FTC and they got fined for not having a general price list. When you look at that general price list and you kind of put everything together, because in there is going to be professional service, embalming, cosmetizing, a visitation, a funeral service, picking up the deceased, a hearse, the lead car, anything that we would use for a funeral service, I'm going to call collectively professional service. You're looking at professional services in our area costing between $5,500 and $6,500. That's a realistic number. Now, as you decrease those services, you don't pay for it. So prior to 1984, what happened was you would walk into a funeral home The funeral director never showed you any charges. He took you into a casket room, pick out this casket, and then he would tell you your funeral is going to cost this amount of money. You never saw it priced. Maybe he told you one. You never had any idea what the whole service was going to cost. And if you said, well, you know, Mr. Funeral Director, I don't want to be embalmed. I don't want you to embalm my dad. He had no way of extracting the cost of that from his charges. If you said, you know what, we don't want to have a church service. We don't want to have a visitation. He had no way of extracting those costs from his charges. In 1984, with the way that the FTC mandated that funerals developed a general price list, you could do that. You can pick and choose the type of services you want, and that will determine your cost of a funeral. Can funerals cost less than that? Yes, they can. There have been situations where I've had, and just recently, somebody walked in and at the beginning of the month, he said, I want to prepay for our funeral, him and his wife's funeral. He said, I don't want to be embalmed. I don't want to be cosmetized. Just pick me up, put me in a casket, take me to the cemetery. Don't even use a hearse. Use your Suburban. No one's going to be there. Just bury me. Use the least expensive casket that you can get. Use the least expensive grave liner you can get, and just get it done. I said, yeah, I can do that. That's not a big deal. But his next comment was, and I only have X amount of dollars, which is less than what it would have cost. And I said, that's not a problem. We'll do that for that. So when I say funerals cost somewhere between $10,000 and $15,000 in our area, this gentleman was buried for $6,000. That paid for the opening of the grave, that paid for his casket, that paid for his burial vault, and of course our services. So yes, they can cost less, and I have that determination to be able to say, you know, we will charge you less. But generally speaking, realistic numbers, that's what a funeral is going to cost. So when you look at a funeral bill, and all funeral bills, no matter what funeral home you go to, they're going to be broken down into 3 sections. One is the one I call professional service, everything the funeral home does. The next section is going to be called merchandise, a casket, a burial vault, anything that they would buy that would pertain to the funeral. And the third section is going to be called cash advances, monies that are paid to somebody else, opening the grave, paying the Milwaukee Journal for the newspaper, paying for death certificates, paying a minister, paying an organist, paying for flowers, anything that would be paid to somebody else. Families will ask us to put that on our bill. I pay it, and then I just get reimbursed. Those are the 3 main sections of a funeral bill. All funeral contracts in the United States have got to be broken down that way, and that's by mandate of FTC. They require that. You're probably thinking, well, what about cremation? Because cremation is really popular. Right now in the state of Wisconsin, 60 to 65% of all the deaths are cremation. That number is going to grow as high as 80%. In some parts of the country, it's higher than that. So people think, well, cremation is cheap. Well, not necessarily. So when you think of funeral costs, think of this. First of all, a funeral home is a business. And funeral directors are terrible business people. They're terrible. In 1984, the federal government made funeral directors sit down with their accountants to figure out what they were going to charge. The federal government at that time thought they were going to decrease the cost of funerals across the United States. And I was managing a funeral home in West Ellis at the time, And I worked Friday and Saturday, putting together a general price list with recommendation from our accountant. On Monday, we rolled out the prices of the funeral. It doubled overnight. It doubled overnight. And that was across the board, across the United States. And I say that because most funeral directors, most owners of funeral homes can't even read a P&L, profit and loss statement. They don't even, they talk to their accountant. Do I have enough money in the bank? Yeah, good, let's go. I want to just do funerals. I don't want to have to deal with the messy part of adding numbers and knowing this is going to cost and this is going to balance. They don't want to do that. Most funeral homes directors do not want to do that. And when I look at people that I know in the funeral business, they got into the funeral business because they wanted to help people. They don't want to be a business person. They don't want to know about marketing. They don't want to know about how to grow their business. They don't want to know about controlling cost. The federal government made funeral home owners pay attention. Now, like the funeral home I worked for, he didn't want to do any of that. He just wanted to make funeral arrangements and take off funerals. And that's why I was hired. I became the manager of the funeral home, and I did the business aspect of it for him. Most funeral home owners don't want to be the businessman. So in 1984, the federal government made funeral home owners pay attention. And they made them pay attention as to what their profit and loss is, because this is a business. If you're going to keep your doors open, what does it cost to open a door? What does it cost to put on your lights every day and to pay your funeral directors? And the second thing that happened was during that time, wages began to go up. What you don't know, and that is probably prior to that, funeral directors were very poorly paid. On an average in Milwaukee at that time, we were working about 60 to 65 hours a week. And funeral homeowners would say, well, I'm just going to give you a salary. And if you had broke down the hours that funeral directors were paid, the amount they were paid very poorly. But things began to change. So all of a sudden, costs are going up, and the funeral director owner has to increase his costs, and that's where we've got to where funerals are what they cost today. In 1972, I was an apprentice, and I remember listening to the funeral director talking to the gardener. And the gardener just bought a Priest, I think it was, and it's a Chevy. And he kept on saying, it's loaded, and which meant he probably had air conditioning and power steering. Think about that, 1972. That's what a loaded car had, air conditioning and power steering. It didn't have FM radio. It didn't have electric windows, none of that stuff. It probably had power steering and air conditioning. Anyways, he says to the funeral director, because he asked, Roger asked him, where'd you pay for that? And he said, $3,300. And it's loaded. Oh, my wife got him to throw in some mats for the car. Well, I use that number because back at that time, the funeral home that I was working for, that was the average price of our funeral, $3,300. When you look at that time period and today, funerals have gone up very little, percentage-wise. You can't even put a pool in your backyard for the cost that you pay for a funeral today. And weddings are considerably more. So going back to what I was saying about cremation. Cremation is 60 to 65% in Wisconsin. It's going to grow higher. And what's happening is you look at, from a business perspective, look at the cost of a funeral. And I'm going to use funeral to generalize cremation and funeral this way, like a teeter-totter. At one time, all the revenue came from caskets and burial vaults and full services. Now, it's just the opposite. And in order for that business to stay in business, they have to charge more for cremation. And what they're charging more for is for what they do. So caskets are going to be way down here as far as revenue. Cremation is going to be way out here. I foresee, I believe this, that I will live long enough to see the cost of a cremation as much as a funeral if you bought a casket and a burial vault. For one thing, you can go online and buy your own casket. And by law, the funeral director has to accept it. And by law, he cannot charge you more to accept that casket. You can build your own casket. I've had somebody do that. And the funeral director cannot charge you to receive that casket or for handling that casket. He must take it and use it as a regular casket. So don't be surprised if people think, well, I think I'm going to try to get around this cost of a funeral by choosing cremation, and it's going to be a lot less. Not necessarily. When you think of cremation, think of this way. Think of an arch, okay? And on this end, you're going to have a family that says, pick up dad at Memorial Hospital, cremate him, throw away the cremains. I don't want to have a service, nothing, no newspaper, just get rid of it, which we cannot do. I cannot dispose of somebody's cremains. That is going to be the least expensive and the least involved service that a funeral home provides. As you go on this arch all the way to the other end, you're going to have people choosing different types of services. I want to see dad. I want to have a church service. At the end of the church service, we're going to cremate dad and then bury him at a cemetery. And when you get to this point, those services are about as much as if you bought a casket and a burial vault. When you think of buying a casket and a burial vault, so you go to, at one time we used to show 30 caskets in our casket room. Now we show none. You come to the funeral home, I'm going to show you a picture of caskets. And I had a suspicion that people did not want to go into the casket room. I would look at people's faces and the reaction, and they were like, I don't want to do this. So I did an experiment. I had professional pictures of these caskets done, and I would ask people, what would you like to do? Go into the casket room and select a casket or pick one out of the book? 99.999 said, we'll pick them out of the book. They did not want to see those boxes of death walk into that room. So I got rid of them, sold them, never replaced them. All we do is look at pictures today. But when you look at a casket, when you think of, I got to buy a casket, caskets are made of steel in this fashion. Out of steel, there's different thicknesses, and that's going to reflect the cost of a casket. 20 gauge is the thinnest metal, 18 gauge a little bit thicker, 16 gauge is going to be the thickest casket. And it will reflect the different cost of a casket. So let's say you walk in, so everybody who walks into a funeral home to buy a funeral should have in their mind a budget that they want to stay within. No different than if you're going to buy a car. You don't want to walk into a dealership and they got all these beautiful cars and it does this and that and da-da-da-da-da. It gets you down the road. You want to have a budget in mind. Caskets are the same way. They all look nice. It just depends upon what they are made of will determine the different cost of a casket. Some caskets are made out of stainless steel, which are going to be more expensive. Some caskets are made out of copper and bronze, which are the most expensive. Anywhere you go in the United States, a bronze casket is always going to represent your most expensive casket. Always, no matter where you go. Unless you go to Arlington, Texas, and they got the silver line casket. That's a lot more. Wood caskets are made out of softwood like poplar wood, pine, and then hardwood, your basic oak, maple, cherry, mahogany, walnut, black walnut. So your black walnut and your mahogany are always going to be your most expensive casket. And on this end, the poplar is always going to be your least expensive casket. Again, it's like an array of different costs, and you can control that cost. They're all going to do the same thing. They all look nice. The cost is just, what the casket's made out of. So when I think of when I think of things of people beginning to look down this road of what I want to do, I want you to look at this because this is really important. I want you to open it and go to the back, the last page. This page, back here. You're here because you want information about what to plan for the end of life. You heard the attorney talk about wills, estates, that process that you need to be aware of because someone has to do it. Please, and don't be like my brother, who is this guy that says, I'll just let the kids take care of it. And I told him why he doesn't want to do that. You want to have some control over what's happening. You want to be able to touch on some of these topics that are here and know about it. If you don't know about some of these topics, find out. Not all that pertains to everyone. I used to have one in here that said about a benefit from trains, railroad, if you have a railroad pension. Now, if you go to the front page, the first page as you open this up, this is the page that every funeral home needs to have, information that a funeral home needs to have to file a death certificate. So when a death happens, we are responsible to start that process. And then we fill this information in, we send it to that person's doctor. That person's doctor signs the cause of death and gets it back to us. Now, if someone's going to be cremated, we cannot cremate that person until the death certificate is signed. So here's a horrible scenario that's true, that happens all the time. The 4th of July is on Monday. Bob dies, let's say, Wednesday night. The son comes in late Thursday afternoon because he's busy, make funeral arrangements, and tells me that he wants his dad cremated. He gives me this information. I send it to the doctor on Friday morning, but the doctor is gone. He's gone Friday, Saturday, Sunday, Monday is the holiday. He may not get back till Tuesday, and he has a whole day full of patients to see. He may not sign that death certificate till Wednesday morning. We've gone almost a whole week. This person hasn't been embalmed because they don't want him embalmed, they just want him cremated. And things are getting to get nasty. This becomes really important because there's some information people don't know. Like it'll ask, what was this person, deceased person's mother's maiden name? Not everybody knows when their birthday was or where they were born. Not everybody knows what their social security number is. The kid's got to find it out. He's got to go digging through dad's stuff to find out what his social security is. All that information must be on a death certificate. And if the social security number is not there, we cannot file a death certificate. The state in Wisconsin, and more states are doing this, have sent a program to every funeral home. And that's how we start a death certificate today. We take this information, put it into the program. It goes to the doctor's office. When he gets to it, he signs it, sends it back to us. And by law, he has 5 days to sign a death certificate. That's what the law is. We have 3 days to file it after he has signed it. He's got 5, we got 3. But that's just the logistics that we have to work with. But we try to get that out to him as soon as possible. And some doctors will say, hey, I got to take care of my patients first before I do this death certificate stuff. Maybe they do it out on the way out the door. Maybe they do it the next morning when they come in. But really, it's really low priority to a lot of doctors. And we're constantly calling them, telling them, we need to get this signed. When you look at the page after that, it talks about memorial information, things that you want to have done. And I think this is an important part because not everybody wants the same funeral service. So, are all funerals the same? Not in the least. When I started in funeral service in 1970, I worked for a funeral home, and it used to say in the paper, in state after 1 o'clock. It never had an ending time. We were there till 10, 11 o'clock at night, and we did that for 2 days. And then the next day we went to church. Now, and this is how funeral customs have changed in our area so much. Now people want to have a 2-hour visitation, maybe a 1-hour visitation. We'll have it at church, have the funeral service, we'll go to the cemetery, we'll have lunch, and we're done. That's the custom we have today. I have a funeral home in Juneau, 30 miles from here. It's in still a very agricultural area. And there, farmers will have visitations for 3 hours one night. They'll have 2 hours of visitation the next day at church before the service starts. And that's just 30 miles from here. You go to Milwaukee, and the customs are going to change again. You go to Chicago, and they're going to change even more so. I got a couple pre-arrangements where I have funeral services that are going to take place in Chicago. They are already up to $3,000 for digging a grave. And that's Monday through Friday. The latest that they'll let us in is 3 o'clock in the afternoon. Saturday is probably another $2,000, and don't even talk to them about a Sunday or a holiday. Don't even discuss it. The custom is just varied quite a bit. So when you fill out the memorialization of what I want, what is it that I want? I think I was talking to somebody earlier, and my dad died in 2005, and he had a stroke 6 years before he died. 2 years before he died, he was getting worse. He asked me to come in and talk to him about his funeral. And I knew that he wanted a church funeral. This is the most important thing to him. And then I got to the point where I asked him, well, what kind of casket do you want? He said, just throw me in the hole. I said, yeah, Dad, I know, but we can't do that. And so it becomes important that you specify those instructions. When I look at my 7 brothers and sisters, they all have different ideas of what they want for a funeral service. I got a son-in-law. I only have one child, and my son-in-law is this hunting kind of guy. He's got all kinds of camouflage jackets and blah, 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 blah. And his idea of my funeral was to put me in a rowboat, light it on fire, and shoot it out in Lake Michigan and let it go. And I don't think so. So I got to make sure that the kind of funeral service that I want is something that's written down, and that's something that Carla and I have done. Not everybody has cemetery space. If you want to be buried, think of where you want to be buried. Not everybody has a monument for a grave space. Think about what you want for a monument. I'll tell you, we got some brochures over there for Miller Monument. I'll tell you a little bit about monuments. The least expensive monument is something that just lays flat. A granite monument that just lays flat. Gray, light gray is going to be your cheapest stone. And then as it gets darker, it becomes more expensive. As you get into the burgundy colors and the black, those are going to be your most expensive stone. But if it's just laying flat on a piece of concrete, that's going to be your least expensive monument. You also have a monument that sits on an angle. They call it a bevel. It's only about this high off, 2 foot high off the ground. Bevel. That's your next expensive. And the most expensive is one that you see that's called, it's a vertical, and it's called a tablet. That thing that goes straight up and down, that's a tablet. And that'll be your most expensive design. Again, light gray is the least expensive. And as you get into the burgundies and black, you're a more expensive monument. But not everybody has a monument. It's something else you might want to think of. I'm talking to a friend of mine who's talking about getting some funeral plans together. I sent him over to the Miller Monument to get some ideas. And he was surprised that the monument that he wanted was $10,000. And I said, well, is it a Wausau red? And he said, well, yeah, this is reddish, kind of burgundy, it's a granite. And those are the, I said granite, you think that they're all strong, right? No, they're not. That's why burgundy granite is probably your strongest granite that you can purchase around here. Right now, black monuments are popular because of the Vietnam era monument that's out there. Those have become popular, but those will be your most expensive stones. When you look at the next page here, and you see funeral estimate, that's what I was talking about, the 3 different charges or the 3 different sections of a funeral bill that will reflect the cost of your funeral. And again, it's like, what? It's not. Because what you do is you say, Greg, I want this. What you say is you come to me and you say, Greg, this is what I want. I fill out the paperwork, I have you sign it, I send it in. It's that simple. It's really that simple. They were backlogged during COVID. Right now, I'm getting them probably within 3 to 6 months. So in our area, if you die, if you're retired military, you're entitled to a free flag. You're entitled to a free grave marker. You're entitled to be buried in a national cemetery if there's space available. Right now, Woods in West Dallas is full. We're using cemeteries up in King, up in Spooner, North Wisconsin. Those are the 2 cemeteries that we use. When those graves were filling up in West Dallas, Wisconsin developed another cemetery in Union Grove. And from what I understand, they are getting close to being full. But if you're a veteran with an honorable discharge, you're entitled to those benefits, and that's it. The military does not pay for a funeral. They'll pay for a certain headstone, theirs, that they will provide, which is a flat bronze marker or a marble. If you drive past Wood VA Cemetery, you'll see all these wood or these white marble headstones. That's what they provide. But they don't provide for a free funeral unless you die active duty military. So when you look at this free estimate or this funeral estimate, it gives you an idea of what you're going to spend for. Professional service, a casket, a burial vault. Burial vaults are not required by the law. People think they are. A casket is not required by the law. Embalming is not required by the law. A funeral director is not required by the law. Wow, you can do this yourself. And who wants to? That's why they hire me. I had a lady, this is when I was in West Dallas, and she had a business and it was well known. Her mother dies. And it's 1 o'clock in the morning and I get a call from my funeral director that says, Mrs. So-and-so wants to take her mother home. I said, what? She wants to take her mother home and put her in bed. She wants her home. I said, she can't do that. That's what she wants to do. And she's insistent that she does that. Okay. I says, let me talk to her. So she gets on the phone and she says, I want to take my mom home. I said, well, we cannot be a part of that. I physically cannot do that. If you want to do that, that's up to you. And she said, okay, that's what I'm going to do it. And I said, well, wait. How are you going to do that? How are you going to get your mom out of the hospital? And she said, well, I'll just put her in a wheelchair. I said, okay, how much did your mom weigh? She's about 150 pounds. I says, can you lift 150 pounds? No, but I'll get her in a wheelchair. I said, okay. So you get her in a wheelchair. I says, how are you going to get her in your car? Can you lift 150? No, but I'll do it. I said, okay. I said, do you have steps at home? She said, yeah. I says, how are you going to get her up the steps? Well, I don't know, but I'll do that. I said, okay. And I'm throwing out all these impediments that she's going to have to go through. And she's, in her mind, thinks she's going to be able to do this. And I said, well, we cannot be part of that. She said, well, still, I'm going to do it. I said, okay. I said, well, you need to speak to the hospital administrator anyways to get permission to take your mom, like you want to do this, home. So he gets on the phone. Now it's like 2:30 in the morning. Hospital administrators don't get phone calls at 2:30 in the morning by crazy people that want to do crazy things. And he knew this lady, and he said, go home and go to bed. The funeral director is going to take your mom to the funeral home. And that's what we did. We become liable and responsible once we take possession of that person. And that's why I was not going to allow her to use our people to do something like that. Again, it goes back to put your wishes down on what you want to have done. And I've had people put down and make prearrangements and things that are out of the ordinary. And as long as I have them and I know how to logistically do something like that, I can get it done. The only thing I will not do is something that's illegal. And I'll give you an example. And this truly happened. Someone came into the funeral home one day and says, I want to make prearrangements for my mom and I want to prepay it. I said, fine, okay, no problem. And I told him how we were going to hold the money and so forth. He says, what? But I'm going to give you 20,000. This is back in 1985, I think it was. I said, I'm going to give you $10,000 or $15,000. He says, but I'm going to tell you what, when she dies, we're just going to have her cremated and I want you to give that money back. Now, I could have done that except for one thing. His mother was on Title 19. So now that's fraud. And I said, you know what, I can't do that. And I explained why. If I had done that, I could have lost my license, which was my livelihood. The funeral home would have been fined, and I probably would have gone to jail. Because what this turned out to be is somebody from the state that was doing an audit. And they wanted to see what funeral homes were doing in a situation like that. And I sent the gentleman on his way, and the owner of the funeral home got a letter about a month later saying, blah, 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 and you got a good funeral director. So I will do anything that you ask me to do as long as it's legal. I put in bowling balls in the casket. I've put in pets that have died in the casket. I've put in a man's 10,000 Ithaca over and under in the casket because that's what she wanted. So, you know, the Egyptians did it. There's no reason why we can't do that kind of stuff. So as long as it's legal, we can do that. I just want to bring your attention to just that third section. Keep in mind that buying professional service and a casket in the burial vault is not the only expense that you're going to incur for a funeral. You got to open the grave. You got to pay a newspaper notice. You got to pay for a luncheon. If you're going to have a luncheon, you got to pay for digging of the grave. All kinds of third-party expenses are involved in a funeral. That's important to keep in mind. Any questions before we kind of wrap up? It's almost 1 o'clock. Okay, so what's happening in the United States, we're going through some fads. I call them fads. Yeah, I've done one. And it was a cemetery in Madison. And so the green burials, those cemeteries want a casket or a container, I'll call it a container that's biodegradable. It's gonna dispose as soon as possible. And the family made it. They made it themselves. It was too small, but they made it. It was too narrow, but they made it. And I think they probably were thinking, I'm going to be real ecologically minded. I'm going to save a few bucks, and this is what I'm going to do. And it was just a disaster. If they would have come to me and said, get me a container where Dad can fit inside and we can have this green burial, I could have done it really inexpensive. And it would have been more dignified than what they end up doing. Yes. So a green burial, in case you don't know this, there are places, some cemeteries, that you can do a green burial. The body can't be embalmed. It's got to be in a biodegradable container. They bury the person about 3 feet in the ground, and it's supposed to dispose of or biodegrade as soon as possible, if the coyotes and dogs don't dig them up. Yeah. So there, for a while back there were people that wanted to have Mom cremated, and they were going to put them in a capsule and send them into space and make a star out of them. I mean, all kinds of goofiness comes up in our industry that people are willing to sell them, and it's goofiness. But there's green burials going on. I've done one in my whole career. Yeah. Any other questions? Well, thank you. I appreciate your attention and coming this afternoon. Isaiah has something to say.
Real quick, I really appreciate Greg and what he does, and he didn't ask me to come up here and say any of this, but I'll tell you right now, one of the first questions I get with almost every probate or trust administration client that comes in is, how do we pay the funeral home? Because think about this. Normally, when you have a will, trust, beneficiary designations, the key to all of that is the death certificate. Where do you get a death certificate? From the funeral home directly. It usually takes a little bit of time. Some people want to have that funeral plan right away, and for the funeral home to start working on it, they're going to incur costs. They may want some portion down or all of it depending on the funeral home. So the question is, how do we pay for the funeral home when no one has access to the estate money yet? So that's why I would strongly recommend, following Greg's advice, or at least talking to a director about what are our options for prepaying for some of this, just to get that ball rolling, because that is one of the first hurdles that we always have to jump over. If there's 5 kids, well, who has to pay for it, right? Out of pocket, if they want it done a certain way. So I strongly recommend.
Not all funeral homes react the way I react to a death certificate, and that is, I act like my head's on fire, my hair's on fire. Get this done, and we constantly call these doctors, sign this death certificate, sign this death certificate, and if you don't, it just sits there. I've known people tell me, it's been 2 weeks and we don't have a death certificate yet. I will tell you, 9 out of 10 times, we have death certificates to the family by the time of the funeral service. The only time we have problems with that is when a medical examiner is signing a death certificate and he has to do toxicology on the person who died to find out what they died from. That may take months. We get it done within 10 days. So.
And I cannot get access to your estate funds until I get that death certificate. Normally, we tell people don't even kind of meet with me until we get the death certificate, unless there's certain circumstances. But, so there's this delay, and so having something prepaid or at least pre-planned, it goes a long way to help your beneficiaries and your representatives.
But if you take nothing else from what you've heard this afternoon, please do this. Get your binder. Put your wills in there, your estates in there, your life insurance is in there. Put your requests in there. Fill out that form that I gave you about funeral services. Put that in there and tell your next of kin where it's at. And they don't have to hunt around and find out where the savings accounts are and what attorney should I call, and it makes their life a lot easier by having something like this. So, All right?
Finish up, so other plots, these two came and opened, and I said, you need to give us all this information. I want to thank them and I want you to know that in Florida, it's simply very automated. Like Rapid does not help on skills, people who are already strong and he's always willing to help all of us, and he's always there. Anytime I am in urgent need for anything, so I really want to thank him for that. And also, we discussed Miller Monument, and Miller Monument just donated a whole monument for the forces of the build up. And we had to put the new section, and when I went there to sort of figure out how much it cost, I said, well, tell me how much is wrong with people and the seniors. And he said, they will have to, and he goes, Bill, he's a great guy, he's a great guy. Thanks, man.
Let me just say something about Miller Monument. They do the inscriptions for us on monuments. What happened about doing the inscriptions, it was unprofitable for all these monument companies to put on a little date and charge you $300, and they were all around the southern part of Wisconsin. It was just not profitable for them to do that. So they gave all that business to a company that would do that. And so this company would go to all these funeral homes, get these dates, and do it. Well, the company went out of business, and nobody wanted to do it. I told the company, I said, why don't you pay your guys more, for crying out loud, keep somebody. He was paying these guys $25 an hour, and they didn't want to do it. It's hot, it's dirty, it's hard to do. So the company went out. I used two companies that would not get it done within a reasonable period of time. One guy took me over a year to get dates on a monument. So I turned it over to them, and they're getting it done within 30 days. So they are a very dependable company. Their prices are very reasonable, and they do a good job. So that's all I can say about them. So thank you.
Awesome.